tough and fosters. I'm just going to speak on one narrow issue, and Mr. Thurman will speak on the others. First, I want to say it really is. I've been on the North Bend Trail, but I've never been to your courthouse before. It really is a very lovely place, you guys. I probably know to be proud. It's very nice. There's some courthouses that are not nearly so nice. The part of our case that I want to mention is I know that EQT has sent you a letter where they said they were upset because when the permit was revoked, they were not told that the decision was going to be made. They were not told it was going to come up at a hearing. And I can tell you that we understand their frustration at not knowing something can happen. But we think that what's good for the goose is good for the gander, or maybe it's the gander and the goose. One of our main points is a constitutional point, that we should have had notice that the permit was applied for in the first place. And we should have had a right to a hearing on the permit. We should have had a right to our expert look at their document and see if that was right. I think the problem that happened is this floodplain ordinance, it's kind of assumed that the people that own the land are the ones that are applying for the permit, and that's what you would ordinarily think. In this case, of course, it's EQT that's applying for the permit because they have the minerals on our surface. And I have put together a memorandum which I will give to the county commission and to the lawyers on the other side, which explains there's a case called Snyder versus Callahan, a West Virginia Supreme Court case. And you know about the Stonewall Jackson Dam and all that when that was put in. There were some citizens that were fighting that, and they lived downstream. They were what's called riparian owners. The water that came out of the dam was going to flow through their land. And they requested a hearing on the permit that the Corps of Engineers had to get from the state before they could put the dam in. And the state didn't give them a hearing. The state didn't give them a right to appeal. And the West Virginia Supreme Court said, if you're a downstream riparian owner and they're going to put in a dam above you that affects you, you've got a constitutional right, because you've got a property interest that's being affected, you've got a constitutional right to notice and hearing. And we think that the same is also true for the application for the floodplain permit. The surface owner should get it, the public should get a notice of some kind in the nearby landowners. We have been trying to get a copy of the study that they submitted. We finally got one when, after they sued you, we got a copy from the courthouse. I had an email that will also give you as late as May 17th. We asked Mr. Sneed, who's the technical advisor from FEMA, from the state agency, for a copy of what he'd shown, and he asked the lawyers for the other side, would you please, is it okay to send them a copy of the study? And that never happened. So we understand their frustration that they didn't get notice of your meeting and of the floodplain administrator revoking the permit. We think that it's good for the goose, good for the gander, that if they're going to do it, they should reapply for the permit, give us notice, let us see the material, let our expert look at it, and if necessary, have a hearing. Thank you very much for your time.